They usually.
William Wagner here with Daniel Borsotti, who just had a case in front of Judge Stephen Fowler.
Stephen P. Fowler.
And he denied the media request without even allowing me to have an oral argument. Daniel, this case has been going on for how many years?
Been about 2.5, 3 years.
And it's a Quality Loan Servicing Corporation is doing what? Doing a perfect white-collar crime and foreclosing on your property?
They're unlawfully trespassing on my property, my land, and my home, and they have no authority to do so. They have no association to anybody. They're just stepping in with real estate fraudulent documents, and they're trying to steal my land.
It appears this is a case that parallels several thousand cases where no collateral account by the lending, quote, institution or bank ever existed. So no money was taken out of one account and lent to the supposed home owner. He created the currency by signing documents. Most people never read these documents. He has asked for A.D.A. accommodations, and judge in this courtroom in Department F49 did a careful, polite dance around the issue, gave him a list. He called the A.D.A. director of the courthouse, but he did not have A.D.A. representation. But the judge was very careful to say, well, we can't discuss your A.D.A. specifics because there's people in the audience. Daniel said what?
I basically told the judge that I have a right to A.D.A. advocate. I've requested multiple times in the past, and that I should be...
Did you waive your...
I did waive my right to, because there was other
privacy.
people in the court, waived the right to privacy because I don't have a problem with anybody knowing anything about my life as an open book, and so I'm here to make a stand for my land. And the A.D.A. advocate is a very important part because without it, I don't have equal justice.
What appears to be happening is Daniel Borsotti, like many homeowners, have been so legally abused by a system they barely comprehend, and they don't want to be understanding that is beneath the authority of these bark-hearted courts. The courts do a careful dance to observe their rules, but still don't grant him A.D.A. help, knowing he's having difficulty processing in real time what's going on. I do have to give the judge some credit because Daniel had his audio recorder and he clearly made it clear to the judge, I'm recording, and he turned it on, put in the date and the time, so he can review later what's happened because he can't process it real time. How could this be a fair trial when he made the point the client of Quality Loan Servicing Corporation has never made even an initial first appearance, which under that bark-hearted court rules, they're required to make at least one appearance. They've never made an appearance. This was the same in Cindy Brown's case in Orange County. It was the same in Teddy Sheldon, who lost her house in Riverside, even though she owed no mortgage on it. There was no mortgage on Teddy Sheldon's house. It had been paid off for years, yet she lost her house to a bark-hearted, I would have to say, criminal. This is what I have to describe after watching dozens and dozens of these. This is an ongoing white-collar crime, so well perfected. And the question I wanted to ask the judge, Judge Stephen Fowler, are you now, Judge, aiding and abetting in a white-collar crime? I wanted to get that on the record. The judge shut the case down. I asked for if you'd indulge me 1 minute. Nope. The bailiff, Officer Aarons, interrupts, said, no, you can't talk to the judge. Why, are these judges above God that nobody can talk to them? Even a living man or woman can talk to God, but we can't talk to the judge. We can't ask him a simple question. This ongoing crime against this man, who has stated over and over on the record, I have trouble processing this. I need someone to interpret the legal jargon. Wasn't that the word used?
Correct.
Legal jargon. The judge was ruffled by that term, legal jargon. But it is legal jargon. It's unintelligible, And you also made a point to say, I'm the Dan the man, the living Dan.
Correct.
Not the all capital dead corporation, which they drag him into their corporate jurisdiction. I think Dan did an admirable job considering he didn't have the help he needed. What's appalling to me, I've been doing media for nearly 20 years. What's really appalling is I put in a media request. They couldn't even find it. They just said it's denied. And after I said, show me your media request. On there, I asked for a specific chance to make an oral argument today, 10th of September. That was in my request. And apparently, he's not even going to allow an oral argument. What happened to the First Amendment? Does this judge really have an oath of office? Did he really take and sign the oath of office to uphold the Constitution, including the First Amendment, freedom of speech, freedom of press? My point here is, if I can't get a camera in there, and most of you people watching out there in Gazula land don't have time to read through all his documents, what the judge said, and see the nuances and understand what's, if I can't get it to you, then is the freedom of press dead? And that's what really worries William Wagner. I'm down here at the Chatsworth Superior Court, building right behind us, and even before we started taping this, a bailiff came out and asked us, did we check this out with the supervising sergeant? And we talked to him, and he said, yeah, as long as you don't obstruct traffic, go ahead. How much does it take for the judge to grant me just 2 minutes to argue freedom of press? He didn't want it on the record. I think we're going to have to appeal this. You got something else you want to say, Dan?
Yeah, I would like to say definitely is that I objected to the attorney speaking because attorney have no authority to speak on behalf of their client unless they have a delegation of power, and the judge refused to even acknowledge that as well. I put out sanctions and the 12 rebuttable presumptions, and the judge didn't even respond to it, and those were filed before the preliminary injunction. They were filed right around the same time as the demur. And last time I was in court, the judge strictly told me directly that he would answer those 12 rebuttable presumptions, and they're very important to this case and the sanctions and a couple other papers that were filed. Today there was a paper filed today, and so I'm with hope that the judge will somehow find within his constitutional heart that he knows that there's a viable case here. It should go forward on the merits. And the judge made comments to other people's cases that were there. And the comments he made contradict what I was trying to get in my case. So it's okay for an attorney to have certain things go their way when I bring up the same code or the case or the law or constitution. I'm denied because I don't have the bar card, but an attorney can get it through, and that really bothers me, and it should bother the American people. I'm Daniel Borsotti to talk about what happened a little bit more in the case Borsotti versus Quality Loan Service Corporation. When I was discussing the situation with Judge Stephen P. Fowler, he cut me off before I had an opportunity to state the exact court code and case law that allows me to object and stop the defending attorney, Matthew Bryan Learned, with a bar card 245599. And one of them is California Code of Civil Procedure 367, which clearly states, on record, every action must be prosecuted in the name of a real party and interest. And California Evidence Code 1401. A, authentication of a writing is required before it may be received into evidence. There's also Evidence Code section 1200 through 1205, which clearly states hearsay evidence. Anything that's stated outside the court is hearsay. So that means that a party must be physically in court to state what they are saying under oath. Otherwise, it's all hearsay and should be thrown out immediately. And the judge refused to allow me to move forward on that. And I imagine I will be moving forward when it comes time for the next hearing with an A.D.A. advocate. The one really crucial code is the codes that restrain an attorney from testifying. An attorney cannot testify for its client. We have Code Rule 5-200. which is a trial conduct, and that is in presenting a matter to a tribunal member. E, shall not assert personal knowledge of the facts at issue except when testifying as a witness. An attorney cannot testify as a witness. And a really important one that I was cut off at right before speaking was Rule 5-210, member as a witness. And a member is a member of the American Bar Association. And that would be C as in cat. The member has the informed written consent of the client. If the member represents the people or a government entity, the consent shall be obtained from the head of the office or a designee of the head of the office by which the member is employed and shall be consistent with principles of recusal. It is not intended to apply for circumstances which a lawyer in an advocate's firm will be a witness. That would be amended by order of the Supreme Court operative September 14. An attorney for the plaintiff and or defendant cannot admit evidence into the court. He is either an attorney or a witness. That would be Trinzi versus Pagliaro, DC, PA 1964, 229, Fed Sup 647. Again, this applies both with federal rules of evidence and state rules of evidence. There must be a competent first-hand witness, a body. There has to be a real person making the complaint and bringing evidence before the court. Corporations are paper and cannot testify. And I'm going to reiterate, they use the word person. I told the judge that I am Dan the man. In other words, I am not a person as they define as a ens legis corporation. And I put everything on record. I'm going to get a copy of the court reporter transcript, and we'll see if everything that was stated there today is on that record. And so there's a lot more cases. I really encourage everybody to go to William Wagner's on One Television, because on YouTube, because he has a lot of crucial and important information. That's where I got a lot of my information from, and it'll help you with your case. There's a lot more to say and a lot more to be done. I got a lot of work ahead of me, and I do want to thank Mr. William Wagner for this opportunity today. Thank you.
That reminds me of the original 13th Amendment, not the one from 1865-66. The original 13th Amendment, which was ratified and passed in 1810 to 1812 under President Madison. In that amendment, it's very short, and it's been left out of all the law books, but if you look back prior to 1865, you will find it in all the state books that are published that existed. The original 13th Amendment was meant to make us all equal under the common law, which makes me conclude this is a bar charter court. This is a corporate court. This is not a common law court. Go find the original 13th Amendment on my YouTube clip and look up Powers versus the Crooked Bank. That video from July 30th, 2018 is still active. Not only the video is on YouTube, but the case that Billy Renee Powers brought forward is ongoing. They have a hearing this next week and again in October. I'm William Wagner from the Chatsworth Courthouse with Daniel Borsotti, who got an semblance of a hearing today. See you.
Thank you.
Good luck, Daniel.
Thank you.